So you've decided you need a defamation lawyer, and now you're looking at a list of firms that all sound more or less the same on their websites. Most people hiring a defamation lawyer have never hired one before. They don't know what to ask, what a good answer sounds like, or what should make them rethink retaining them. So in this video, I'll give you 8 questions to ask on that first attorney consult, along with what you're actually listening for in each answer. I'm Jake Lauder with Mink Law, the nation's leading law firm exclusively dedicated to online defamation, content removal, and online harassment issues. Defamation is a pretty niche corner of the legal world. Some of these questions are the ones that separate firms that genuinely live in this work from the firms that dabble. Other questions I've included are about the practical things you want to know before you sign an engagement agreement with a firm and start writing checks. So let's get straight into it. Question 1. How much of your practice is actually defamation and online reputation work? This is the first question for a reason. A lot of general law firms will take a defamation case if it walks in the door, but they may be more focused on other areas like employment law or copyright. But defamation has its own rules, its own quirks, and its own playbook. A firm that does it once in a while will be learning on your case, and you'll be the one paying their tuition. What you're listening for is specificity. We handle a lot of litigation, including defamation, is a very different answer than defamation and online reputation is most or all of what we do. Neither is automatically a deal breaker. They could still give you some examples similar to your case, but the more focused the practice, the more reps they have with the exact problems that you're facing. Question 2. Have you handled cases that look like mine? Defamation cases come in many different shapes, and the playbook changes a lot depending on the shape. A disgruntled former employee posting on LinkedIn is different from an anonymous troll on a forum. These platforms behave differently. The attackers behave differently. The legal options and realistic outcomes are different too. Ask whether they've handled matters with the same shape as yours. Same kind of platform, same kind of attacker, same industry, same kind of harm. You're not looking for a guarantee. You're looking for pattern recognition. A lawyer who has seen your situation 10 times will spot things a lawyer seeing it for the first time simply will not. Question 3. What are the realistic outcomes here, and what are the risks? This is the question that separates honest lawyers from ones who are just trying to close a deal. A good defamation lawyer will tell you what's likely, what's possible, and what's a long shot. They'll talk about how strong your claims actually are, how hard it'll be to identify the person posting, how cooperative platforms tend to be in cases like yours, and how realistic it is that you'll ever collect money, even if you win. They'll also walk you through the risks. Filing a defamation lawsuit can sometimes draw more attention to the very content that you're trying to suppress. That's the Streisand effect, and it's a real consideration in certain cases. Some states have laws designed to protect free speech that can actually force you to pay the other side's legal fees if a court decides your claim targets protected speech. And the legal process can sometimes make things a part of the public record that you'd rather keep private. Be wary of anyone who only talks about the upside. We'll get this taken down fast, or we'll get you a big verdict with no discussion of cost, timeline, or risk is a sales pitch, not a legal assessment. It's rare that anyone truly offers a guaranteed outcome when it comes to working with the law. It's a green flag if they tell you about alternative options you may have outside of their practice, or if you'd be better off not taking legal action at all. Question 4. What does this actually cost, and how do you bill? Defamation cases get billed a few different ways, and you want to understand which applies to you. Most are billed hourly, usually with a retainer paid up front. Matters like content removal work that don't require a lawsuit can sometimes be handled on a flat fee. Contingency arrangements, where the firm only gets paid if you win, do exist in defamation but are very uncommon because even strong cases often have problems collecting damages, and most firms don't want to take that risk. What you want is a clear picture of the likely cost range for each phase of the work. The initial investigation and demand letters, filing a lawsuit if it comes to that, the discovery process, and trial. Nobody can give you an exact number because so much depends on what the other side does. but an experienced defamation firm should be able to give you a realistic range based on what they've seen with cases like yours, and should set expectations from the start. If you can't get any estimate or clarity at all, that's a red flag. If the estimate sounds too good to be true, that's a different kind of red flag. Question 5. Who is actually going to handle my case? At a lot of firms, the person you meet with on the consultation isn't the same person that's going to be doing the work day to day. That's not automatically a problem. Good firms use associates and paralegals on purpose to keep costs down, and attorneys often collaborate. But you should know who is actually running your case, who you'll be communicating with, and how senior the attorney making the strategic decisions is. Ask directly, who will I be working with? How often will we communicate? Who decides the strategy? For a matter that could run several months or longer, those relationships matter. The first consult isn't just about legal options, it's also about getting to know each other and deciding if your personalities are a good fit. You want to know the answers before you sign the engagement letter, not after. Question 6. What's your approach before filing a lawsuit? A lot of defamation matters get resolved without ever filing a lawsuit, through demand letters, negotiated takedowns, platform escalations, and direct outreach to the poster once they've been identified. A firm that jumps straight to litigation in every single case isn't necessarily serving your interests. Lawsuits are expensive, they take time, and for many cases they aren't the right first move. On the other hand, a firm that only does pre-litigation work and never actually files lawsuits has its own credibility problem. When the other side knows that you won't sue, the demand letters carry a lot less weight. What you want is a firm with both gears. One that can resolve a matter quietly when that's the right play, and one that can actually take a case through a courtroom when it needs to go there. When is it time to be aggressive? When is it time to amicably negotiate? You want someone with the right attitude and flexibility for these kinds of sensitive matters. Question 7. What does success actually look like in a case like mine? This sounds similar to the outcomes question, but it's a different one. Outcomes are about what's possible in general. Success is about what you're trying to aim for together, and how you'll know if you got there. The answer to this one reveals whether a firm has actually thought through your specific case, or is just running a template. For a medical practice getting hammered by fake reviews, success might mean a specific number of removals and deterring future posters, not going to a courtroom. For a CEO facing an anonymous attack campaign, success might mean unmasking the person behind it and getting a court order to stop them, with money being secondary. For a news article with factual errors, success might be a correction or a retraction rather than a full takedown. If the answer sounds like it would apply to any defamation case that walked in the door, the firm probably hasn't thought about yours yet. What you want is an answer that's specific to your facts, your goals, and the realistic options in your situation. Question 8. If this case isn't a good fit for you, what would you suggest? Not every case is a fit for every firm. Some cases are too small for certain firms to handle economically. Some fall outside the firm's geographic reach or experience. Some aren't actually defamation claims at all, and some cases simply don't have a viable legal path. A firm that's willing to tell you that is a firm thinking about your interests, not just their pipeline. You just want a sense that they'd actually be honest if your situation called for a different solution than what they can offer. A couple things to keep in mind as you compare firms. Trust your read of the conversation. If you leave a call feeling like you got a clear, honest assessment, including what's hard about your case, that's a good sign. If you leave feeling like you just got a sales pitch, trust that read too. And move reasonably quickly. Not because you should be pressured into a decision, but because online evidence can disappear. The time limits to file a defamation lawsuit can be as short as 1 year, depending on your state, and attacks that could have been contained early often get much harder to contain once they've spread. If you want clarity on what to do next, give us a call. We offer free case evaluations, where our intake team takes an initial look at your situation and points you in the right direction, whether that's with us or with someone else. And if you want an even deeper dive, we offer paid, no obligation, confidential consultations with our attorneys, where they review the full details of your case and walk you through the best strategy for your specific situation. Either way, you can reach us at the number on the screen, or head over to minklaw.com and fill out our contact form. This is Jake Lauder with Mink Law. Thanks for watching. I'll see you in the next video.